Hello, my name is Stephen Alaman. I'm with Disability Rights Texas, or DRTX. We are a nonprofit organization in Texas devoted to protecting the rights of people with disabilities in a large number of areas, whether it's housing, transportation, employment, and also in public education. Today, we're reviewing several different key bills passed by the Texas legislature in 2019 that affect students with disabilities as kids get ready to go back to school for the 2019-2020 school year. We've already covered several topics earlier in the series, and this segment focuses on a new state bill that prohibits school districts and school personnel from using what we call aversive techniques on students with disabilities. So generally speaking, what is an aversive technique? It's an approach to intentionally inflict significant physical or emotional pain or discomfort on somebody in an attempt to help stop that person from engaging in some sort of behavior. So generally speaking, we think of aversive techniques as a really misguided approach to changing someone's behavior. From a policy standpoint, we prefer positive behavioral reinforcements and directives rather than negative. And this legislative session, the Texas lawmakers agreed that aversive techniques such as holding and restraining a student, going so far as to pepper spray them, other things that inhibit their ability to breathe or move their body parts are all not the thing to do in our public schools to help a student with a disability. Now, of course, students with disabilities have many different needs. Sometimes those needs do include or involve behaviors that we as educators, as parents, do recognize that it's better for that person not to exhibit those behaviors or try to minimize them. Now, we want to be clear that not every student with a disability has behavioral issues or behavioral issues even that go so far as to need some sort of positive or negative consequences. But there are many, though, in Texas public schools where this is a real issue. So again, lawmakers have said that schools starting this fall can no longer use aversive techniques. And the law spells out exactly what those prohibited activities are. Now, to help school districts implement this new state law, our State Department of Education, the Texas Education Agency, or otherwise known as TEA, will be amending state regulations to provide detailed guidance to schools so that they understand what is and what is not allowed with regard to students with disabilities. Now, that process of state rulemaking will take some time. So before that can happen, we encourage parents to visit during the Admission Review and Dismissal, or ARD, committee meeting if your child exhibits certain behaviors that might be subject to negative or positive consequences. Review with your committee how updated the Functional Behavioral Assessment, or FBA, is. That's a specific type of evaluation of a student with behavioral needs to identify why those behaviors happen and how do we best redirect the student to more positive outcomes. That's a really important basis for programming in the student's plan. So at that ARD committee meeting, do ask and ensure that the FBA is updated. That will inform both goals in the plan as well as what we know as the Behavioral Intervention Plan, or BIP. Now, in addition to the rulemaking that the state agency will follow to provide detailed guidance on the ban on aversives, TA also has a new charge in this legislation. The legislation, by the way, is Senate Bill 712 and House Bill 3630. Those two bills have the same prohibition against aversive techniques and also require that TEA to do something else. TEA must provide positive guidance and training to school districts about alternatives that they can rely upon to help student behaviors. Now, it will be incumbent that that guidance be evidence-based, be based upon sound practices that are acceptable to special education advocates, parents, and administrators alike. So we'll be watching and encouraging TEA to get that guidance out just as soon as possible. One final note about this legislation, and that it is also important for everyone to know that if you believe that a child's rights have been violated because of the use of an aversive technique, they go so far as to physically injure or harm a student, you have the right to file a complaint. You have the right to request a Child Protective Services or CPS investigation, because it might also violate our state law that prohibits child abuse. So hopefully it won't come to that, but we do want to let you know that you have several recourses beyond just appealing to the school principal or the special education director in your district. You can go to outside state agencies such as Child Protective Services if you believe your child was severely harmed. In closing for this segment, we'll remind you that we have a lot of resources on our DRTX website. That's www.drtx.org. We have resources to help families as they go back to school, including a general document we call the IDEA manual that provides general guidance throughout the special ed process. Finally, I hope that you will be following us on our social media on Facebook, Twitter, and Instagram, as we are always updating those platforms with the latest news and developments affecting people with disabilities, including students with disabilities in our Texas public school system. We're going to continue this series of updating the public about new state laws as the school year gets underway. So stay tuned for 2 more segments coming this afternoon. Thanks for joining us now.